Today is March 31st, 2020, and we are going to cover some new developments in the law that are important during this time of pandemic. In particular, I'm going to cover the latest round of quarantine and isolation measures, how some states are reacting to the enormous increase in demand for firearms, and how the March 10th, 2020 declaration under the PrEP Act may affect you or someone that you love in the future. And now, here's the brand new intro that I had developed for my channel. As you have probably heard, a number of state governors have enacted orders that require out-of-state travelers to self-quarantine for a number of days or face fines or even jail time. These orders are clearly designed to discourage travelers from New York and other states from coming into the state that enacted the orders. For example, Rhode Island started stopping cars from New York and ordered any travelers from that state to self-quarantine for 14 days on arrival. There are even reports that law enforcement and the National Guard are going door to door and looking for New York travelers to force them to self-quarantine or to leave Rhode Island. After New York Governor Cuomo threatened to sue, Rhode Island later changed that order to encompass all out-of-state travelers. New Mexico's governor similarly ordered that everyone traveling by air into New Mexico self-quarantine for 14 days. Kansas has an order for any travelers from Florida, Washington, California, New York, New Jersey, Illinois, Colorado, and Louisiana. Texas has some similar orders, and Florida has been very aggressively targeting travelers from New York and Louisiana. The reason for these orders is pretty clear. People are fleeing from areas and states with high amounts of infections and heading for areas that are perceived to be safe. For example, some families from hard-hit areas of Chicago have been making arrangements in other Illinois towns, as well as across the border in Iowa, Indiana, and Wisconsin, and plan to stay there for a month or longer. The residents of these areas are understandably concerned about the new arrivals and whatever they might be bringing with them, like active COVID-19 infections. And that brings us back to the travel restrictions and self-quarantine orders that some states are attempting to impose. Putting aside how effective or ineffective these types of orders are, many of them are likely to fall if they're challenged. As I explained in my previous video, which should be popping up at the top of this video now, these types of blanket restrictions are generally not authorized under the police power. Over the next few weeks, you are likely to see numerous lawsuits over these types of orders, and these orders will probably be modified in certain ways to make them enforceable. To be clear, it is perfectly legal and even responsible for state governments to require infected persons to quarantine as long as there is evidence that a particular person actually is infected or had contact with someone that was infected. And it is also legal for state governments to quarantine infected regions of their own states, meaning to not allow anyone into or out of a disease hotspot within their own state. However, for states to impose a quarantine on a person entering the state, there generally must be some evidence that a person is infected or at high risk of being infected, and these blanket prohibitions probably do not qualify. In addition, these types of orders clearly impact the right to travel, and when challenged are going to create some interesting law in the future. On the other hand, the federal government would almost certainly be able to quarantine an area as long as that quarantine is well thought out and sufficient provisions were made for the people inside the quarantined area as well as those outside of the quarantined area. So that means that the federal government could, for example, quarantine the borough of Queens in New York, an area that has been especially hard hit by COVID-19, and prevent anyone from entering or leaving Queens. However, for political reasons, like the governor of New York threatening to absolutely destroy the stock market, such a quarantine is unlikely to occur for now. One thing that states concerned about infected travelers could do would be to set up checkpoints where they ask medical questions, take temperature measurements, and conduct other non-invasive screenings before allowing an out-of-state traveler in. Such measures would likely be authorized under the police power and are probably constitutionally sound if not applied disparately. Another area where you're beginning to see some legal activity is over gun sales. Much of the country is presently under a shelter-in-place order, and in some of the states under a shelter-in-place order, gun shops have been deemed essential and remain open, and in others, gun shops have been closed, and predictably, lawsuits have followed. Gun activists have filed lawsuits in California and New Jersey challenging orders that close gun shops for the duration of a shelter-in-place order. In particular, the activists claim that closing the gun shops during the shelter-in-place order is a clear violation of their Second Amendment right to bear arms. And quite frankly, they probably have a point. It seems very difficult to justify that liquor stores are deemed essential while gun shops are not. While these cases will take a significant amount of time to work through the courts, they should be very interesting with regards to the Second Amendment and undoubtedly are going to be watched very closely. All the shelter-in-place orders are also likely to lead to a number of lawsuits under the Fifth Amendment, which prohibits the taking of private property for public use without compensation. In particular, Shomerick Bells, a small firm in Pennsylvania that makes handbells and chimes, filed a lawsuit against Pennsylvania's governor and other officials, claiming that the governor's shelter-in-place order constituted a taking under the Fifth Amendment. This is going to be a very interesting lawsuit, although, in all honesty, I doubt that it will succeed. The Supreme Court has long held that states can regulate and even prohibit certain property uses without counting it as a taking. In addition, if the courts should rule that this is a taking, the liability on state governments is going to be almost unlimited. Accordingly, I would feel fairly confident that this lawsuit is not going anywhere. Finally, I wanted to address one more area in today's video, which is the March 10th, 2020 declaration under the PrEP Act by Health and Human Services Secretary Alex Azar. The PrEP Act is short for the Public Readiness and Emergency Preparedness Act, and it is a tort liability shield for manufacturers of covered countermeasures in the event of a declared public health emergency. And the PrEP Act has now been invoked to provide immunity to liability for activities related to medical countermeasures against COVID-19. The PrEP Act was designed to encourage rapid production of covered countermeasures in the event of a public health emergency. The theory is that by removing the threat of liability, companies would be able to rush vaccines and drugs onto the market to fight a public health emergency. However, in this case, the PrEP Act has been invoked with extremely broad protections. For example, you have probably heard that there is a shortage of N95 masks, respirators, and other forms of personal protective equipment, or PPE. Under the declaration, manufacturers of PPE are expressly exempted from liability for COVID-19 through 2024. So if a nurse who has to fight to get her hands on a mask is actually lucky enough to get one, and it happens to be defective and that nurse catches COVID-19 and becomes sick or even dies because of the faulty mask, there is absolutely nothing that she can do about it. It goes without saying that this provision applies to any drugs that are administered to patients to fight COVID-19, as well as to other forms of treatment. I just want to emphasize the liability protections the PrEP Act grants are broad, very broad. The Supreme Court looked at the PrEP Act once before in the case of Brusiewicz v. Wyeth, and Justice Sotomayor noted that the PrEP Act provides more protection than the Federal Vaccine Act, which at least allows some recourse for people that are injured by vaccines. Under the PrEP Act, the only recourse is the so-called Countermeasures Injury Compensation Program, or CICP, which publishes no decisions and allows no appeals. So it is impossible to analyze how decisions have been made in the past under the CICP. In addition, a manufacturer can be held liable for willful misconduct, which effectively requires that the manufacturer know that their product is defective before they can be held liable at all. Given the number of people that are being treated for COVID-19 and the number of healthcare workers and first responders involved with treating the sick people, it is inevitable that people are going to be injured by faulty products. Probably a lot of people, and maybe even someone that you know. And regretfully, because of the PrEP Act, they're going to have very limited, if any, recourse. I should note that the PrEP Act itself is almost certainly going to be challenged as not being constitutional, and smart lawyers can often find ways to work around things like the PrEP Act. You can see the actual declaration by Secretary Azar at the link I placed in the description below. And that is all that I have for you in this video. Thank you for watching. If you have any questions, please feel free to place them in the comments. I review all of them. And as always, if this video was informative or entertaining, a like would be appreciated. And if you want to see more content like this in the future, I would love to have you on board. Please subscribe and turn on notifications. And until next time, Have a fantastic day.